Good morning, everyone. This is Kristen O'Neill. I'm the Assistant Director of the New York State Committee on Open Government. And today we are doing a program, a training. It's for anyone who is interested in learning more about the Freedom of Information Law. It's not really directed at specifically any one type of individual, but I'm hoping that everyone will find it helpful, that it's for members of the public, it's for our local government employees, it's for state employees, anyone that just really wants either a refresher or to learn from the start a little bit what their rights and responsibilities are under the New York State Freedom of Information Law. Because I'm a one-woman show and I am not talented enough to keep track of the chat function and do the presentation as we go along, what I'm going to do is I'm going to present and talk for the first probably maybe about an hour, and then what I would ask you to do, and you can do it as we go along, that's perfectly fine, if you could use the chat function to enter your questions that you would like addressed. And maybe they'll end up getting addressed anyway without you having to ask, but if you want to put them in the chat box as we go along, and then at the end, what I'll do is I'll just go through the chat box and address any questions that came up. If you sent me questions in advance, I'm hoping I remember to address all of those. If not, feel free to remind me through the chat function that you had a question and it hadn't been addressed yet. So we'll get started. The New York State Committee on Open Government is I like to refer to us as a quasi-independent entity within the New York State government. We were created in 1974 when the New York State Freedom of Information Law was passed, and our role is to provide advice, opinions, guidance regarding open government statutes, including the Freedom of Information Law, the Open Meetings Law, and the New York State Personal Privacy Protection Law. We are open to everyone. Anyone can call our office. We are available via phone, mail, email, to answer questions or to provide guidance or opinions to anyone who asks, members of the public, government employees, members of the media. We're here for anyone that has questions regarding the Freedom of Information Law. Something to keep in mind is that our office does not have enforcement authority. We don't have the ability to, for example, investigate complaints against agencies or public bodies, but we can provide advice, we can prepare legal advisory opinions, and hopefully people find those advisory opinions educational and helpful and persuasive. I know in the past, during litigation involving FOIL and open meetings law issues, our advisory opinions have been cited, and often the courts they don't always agree with our office, but they often find, because this is what we do for a living, that our opinions are persuasive. Up on the screen, you're going to see my contact information. So if you have questions, you're always welcome to contact me directly through this information. My email address is there. I'm going to do it at the end. I uploaded the PowerPoint to the WebEx program, but a couple of people mentioned to me that they were having a hard time figuring out how to access it, and I unfortunately am not the biggest tech expert, so I wasn't able to give great directions about how to do that. So what I did last month when, after my open meetings law program, was I just basically did a mass email to everyone who registered for the program, and I can send you the PowerPoint. If I am unavailable for any reason, there's our executive director's name is Shoshana Boulay. She is also available for questions and advice. You can always email, we have a generic email box, which is kind of easy to remember. So instead of the kristen.o'neill@dos.ny.gov, it's COOG, which is our acronym, COOG@dos.ny.gov. So that's our contact information. Freedom of Information Law is codified in New York State Public Officers Law, Article 6, Sections 84 through 90. A copy of the statute is available right on our website, so we try to make it easy to find for you, and you don't need to go searching in any legal texts for it. It's right on our website, as well as a copy of the New York State Open Meetings Law and Personal Privacy Protection Law if you have questions. We also have on our website, this is, it's in the process. It's been a slow process, particularly because of COVID. We've had to slow down a little bit, but this is what our website looks like. And at the top of the screen, there are drop-down menus. So for example, under the I would like to, there's some sample language for submitting FOIL appeals. You can actually, under the I would like to menu, you can view recordings of Committee on Open Government meetings, the meetings of the actual Committee on Open Government, which is an 11-member body that meets a couple of times a year to discuss open government issues and to make recommendations for our annual report to the governor and the legislature. There's also, this is where you will find recordings of these programs. So if you have friends and colleagues that missed this program and would like to view it at a later time, or if you just forgot something, want to go back and check on what I said, the recordings are under that heading of I would like to. Under the Freedom of Information Law, you have copies of the statute, you have copies of our regulations, our advisory opinions, and FOIL case law summaries. Same under the Open Meetings Law. Open Meetings Law doesn't have regulations per se, but there's a copy of the statute, there's a copy of the advisory opinions, case law, personal privacy protection law, which just as a side note only pertains to records maintained by state agencies. So if you are a local government rep, if you work for local government, or you're interested in records maintained by local governments, the personal privacy protection law is sort of just out the window. It's not really pertinent to your day-to-day life. Under publications, we maintain a copy of our annual report to the legislature and our annual report to the governor and the legislature, and a copy of a very helpful pamphlet publication called Your Right to Know, which if you're a newbie to FOIL and the Open Meetings Law, it can be a bit of a lifesaver because it's just a nice overview of both statutes. And then you'll see on the right-hand side of the screen under News, that's where I will post, if I'm going to be doing another program, I post that information there. And anything, for example, every time the governor's office has renewed the executive order relating to the suspension of the in-person requirement relating to the Open Meetings Law, we try to post that information there to keep people aware that it has been extended again, or just anything new and that we think would be interesting to the public relating to open government statutes. That's where we post that information. And of course, there's also contact information about how to get in touch with us. So as I mentioned earlier, the New York State Freedom of Information Law was originally acted in 1974. It was pretty limited in scope. Essentially, the original statute had a list of the types of records that you could access, but if the record wasn't on the list, you were out of luck. It was not accessible unless some other statute provided you access with it. Nobody really loved that version of the statute, and 4 years later, it was completely repealed and replaced with what, in essence, is the current version of the statute. Of course, there's been amendments to the statute since then, but the current version is based on the presumption of access. So often I get the question, is this record FOILable? Can I FOIL this? And my answer is, well, generally, you can FOIL anything you want. You can make a Freedom of Information Law for any record maintained by a government agency. I'm not promising you that you will get it, but there's a presumption of access under the New York State Freedom of Information Law. Start with the assumption that all government records are subject to FOIL disclosure, and then the agency will have a right and sometimes an obligation to review those records to determine whether record or a portion of the record fits into one of the permissible grounds for denial. And I think it's important to note here that there is specific language in the statute that talks about records or portions of records. This reflects an assumption on the part of the legislature that if a record contains information that is subject to one of the grounds for denial, but that if the rest of the record could be public, there is a presumption on the part of the legislature that that record would be redacted and not withheld in its entirety. That you would either through, whether it's old-fashioned Sharpie or whether it is through an electronic. For example, I use Adobe Pro and I am able to redact records using an electronic redaction program, but there is an obligation in most instances to redact records if there's a mix of disclosable and non-disclosable records. There are a couple of exceptions to that, and I'll talk about that a little bit later. Someone had asked me about what the appropriate process for redacting records is. Someone mentioned, do we need to use a Sharpie or is whiteout appropriate? My thought is you want to make sure that the person who is receiving the records can tell what has been redacted. You don't want to make it seem like what has been redacted was never there in the first instance. The person who's receiving the record, it should be clear to them that a portion of the record has been withheld. And as I say, it doesn't have, I'm using Sharpie obviously generically. It doesn't have to be through, a thick black marker, but it should be in a manner that makes it clear to the requester that a portion of the record has been withheld. Who is covered by the Freedom of Information Law? FOIL governs access to agency records, and the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof, except the judiciary or the state legislature. So at a very basic level, we all probably have a fairly good understanding of what a government agency is. From, at the top of that pyramid, maybe we have the governor's office, the executive. Then we have all of the executive agencies. I work for the Department of State. That's an executive agency. Department of Health, Department of Labor, Department of Education. You have other agencies that are operated under other elected officials, such as the Office of the New York State Comptroller, the Office of the Attorney General. Those are all state agencies subject to FOIL. And then you work your way down. It's county level, cities, towns, villages, fire districts, school districts. There are thousands of units of local government across the state of New York. And if anyone ever asks me, unfortunately, we are a very small office. If I haven't mentioned it yet, we have my executive director, Shoshana Boulay, myself, and our wonderful administrative assistant, Candace Watson-Cottle, and that's it. We're a three-person team. And often we get the question, well, can't you just call them and tell them that they have to do this, or can't you investigate this complaint for me? We just don't have the staff. So what our role is, it's sort of the old adage of teaching a man to fish. We try to provide the public with the tools that they need so that they can advocate for themselves. And when you're dealing with that, and I bring this up just because the sheer volume of local government agencies across the state of New York, we just unfortunately do not have the manpower or the ability to investigate complaints or to enforce the statute with regard to the entire state. And here you'll also note that I emphasized that the judiciary is not an agency that is covered by the New York State Freedom of Information Law. So the courts, from New York State Supreme Court, Court of Appeals, appellate divisions, all the way down to your local town and village courts, they are not required to respond to a New York State Freedom of Information Law request. It's not to say that those records may not be publicly available, but they're publicly available through other statutes that are outside our office's advisory jurisdiction. There are provisions in FOIL relating to access to records maintained by the state legislature, but the state legislature is not considered an agency in the same way that all other government entities are considered state agencies, excuse me. With the state legislature, access to their records sort of reverts back to the 1974 version of the statute, where the law contains a list of the types of records you are entitled to if you make a FOIL request to the New York State legislature. And if it's not on that list, you're out of luck, in terms of FOIL anyway. The term records. The term records is defined very, very broadly under the New York State Freedom of Information Law. There's a difference between what is considered a record for the New York State Freedom of Information Law and, for example, what the New York State Archives considers a record. For example, if my boss and I are trying to decide if maybe we want to order out lunch today, and we decide to email each other questions about what we would like to have for lunch, once we use our state email accounts to email each other about even the most insignificant matter, those emails become records that are subject to rights of access under the Freedom of Information Law. Again, they don't necessarily need to be disclosed in response to a request depending on content, but once they exist, record means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. This means, obviously, paper. It means data maintained on a database. It means emails. It means video. It means audio. It is very, very broad. And so when someone asks me, is this a record subject to FOIL, my answer most likely is going to be yes. And then you look to see whether any of the exemptions are going to apply. Under the Freedom of Information Law, an agency is not required to create records. So for example, this often comes up, sometimes attorneys or even lay people like to use the Freedom of Information Law as a means of discovery, or as what we like to call it, like interrogatories. They send a list of questions to the records access officer for the agency, asking the agency to answer questions for them. And that's not what the intent of FOIL is. FOIL governs access to existing records. If you do not have a record, and again, that's defined very broadly, it could mean that the information is contained in a database and you need to query the database and run a report. But if you do not maintain a record that contains the information sought, you are not required to manually create a new record or to answer questions in response to a FOIL request. This does not mean that you're not required to make copies of records or to convert them into a preferred format if that is possible. Sometimes I've been offered the question, well, we have paper copies of records and someone is asking us to scan them and email them to them. Isn't that creating a new record? No, it's not. It's just making a copy in electronic format of an existing record. That is not creating a new record. Extracting data from a database and putting it into an Excel file or an Access database or whatever the case may be, that is not creating a new record. It is merely taking a record that already exists and putting it in a format that is accessible to the public. There are 3 exceptions to the requirement that you're not required to create records. The first being is that every agency that houses a public body is required to maintain a record of how each member of the public body voted on a matter. So this is odd. You would think this would be contained in the Open Meetings Law, but it predates the Open Meetings Law. The Open Meetings Law has provisions that state what the minutes of a meeting of a public body must contain. But in addition to those requirements in the Open Meetings Law, there's also a separate requirement in the Freedom of Information Law that states that you must maintain a record of how each member of the public body voted. Every agency is required to maintain a list of the name, public office address, title, and salary of all of its employees and officials. So this is something that is required to be maintained and be made available upon request. And the last item is a reasonably detailed subject matter list. If you are a local government entity and you're thinking to yourself, oh goodness, we don't have a subject matter list, I can perhaps comfort you in some way that many municipalities adopt the record retention and disposition schedules put out by the New York State Archives as their reasonably detailed subject matter list because they line up so perfectly. What is required to be maintained and just, the schedule for how long it must be maintained lines up pretty nicely with what we would expect would be contained in a reasonably detailed subject matter list. So if you as a local municipality would like to adopt that retention and disposition schedule as your subject matter list, if you haven't already done so, that's perfectly acceptable and reasonable. For state agencies, it's a little bit, they're probably going to need to go into a little bit more detail because the record retention and disposition schedule put out by the New York State Archives applies to all state agencies. So each individual state agency is likely going to need to add to that subject matter list to include records that are agency specific. So, excuse me, I'm going to take a sip of water here. I was talking a little bit about the difference between creating a record and preparing a copy of a record. This comes up fairly frequently. There's a provision of the Freedom of Information Law that states that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copy or have such copy made by engaging in outside professional service. This may mean providing scanned records instead of photocopies. It may mean providing a record in Word format instead of PDF. It may mean providing an Excel file instead of a PDF. Many government agencies that I've encountered and spoken with express concern about providing records in original manipulatable formats. However, it is an obligation on the part of the agency to provide the records in the format, if possible, if you have the ability to do so, to provide the record in the format in the medium requested. If they want an editable document, if they want an Excel file instead of a PDF and you have the ability to do that, you must. If they end up playing around with the data and manipulating it, that's on them, but you can always, if someone ever comes back and questions, hey, look, I saw a copy of this record that, John Doe showed me, you can say, well, that's not what we gave them. They played with it and they made it different. This is what we gave them. This is what the original data showed, or this is what the original record reflected. And again, I think some of these things they may have already said. This was language that was, fairly recent in the grand scheme of things that was added to the Freedom of Information Law, that any programming necessary to retrieve a record maintained in a computer storage system and to transfer that record to the medium requested by a person or to allow the transferred record to be read or printed shall not be deemed to be the preparation or the creation of a new record. And then I think that was specifically meant to address the issue of information stored in a database. You have information stored in a database, and the individual comes to you and says, I'm looking for this data that reflects this information. If you as an agency have the ability to query your database, to enter a couple of search terms, whatever the case may be, and run a report that contains the information being sought, you have an obligation to do that. And switching from the obligations of an agency over to the obligations of the requester. The requester doesn't have many obligations. One is that they have an obligation, if the agency chooses to impose it, to put the request in writing. There's nothing saying that an agency can't accept a verbal request for a verbal freedom of information law request. However, all agencies have the right to require that a freedom of information law request be in writing. The next obligation on the part of the requester is that they must reasonably describe the records they are seeking. And to determine whether the requester has reasonably described the records sought, the first thing is sort of that gut reaction. Am I reading this request and can I figure out what they want? If the person reading the request, if the records access officer who's responsible for coordinating the agency's response can't even figure out what's being requested, well, then the person probably hasn't reasonably described the records sought. Another very common scenario is that the person may be requesting records that the agency knows that they maintain, but the way that the request has been phrased is that they're asking for records which does not, the agency is unable to locate or retrieve the records with reasonable efforts. For example, if your filing system is alphabetical and perhaps you have property files, building permit files, property files that are maintained so that they are searchable either by name of the property owner or perhaps parcel lots or address. If someone provides that information and asks for records relating to that property by providing that information, the likelihood is you're going to be able to respond. You're going to be able to go to your files and pull that information. However, if somebody comes to you and says, I would like building permits for all blue houses in the neighborhood, the likelihood is you are not going to be able to respond. You know perfectly well there is a very good chance that you have records relating to blue houses in your files. But that's not how you maintain your records. And you're under no obligation to go through thousands of property records to find the ones that specifically relate to blue houses. It's just, do you maintain your records? Does the agency maintain your records in a manner that would allow you to locate the records being sought with reasonable effort? And then this will often depend on whether the records are paper or electronic. It's often much easier to search electronic records by a number of different criteria than it is to search paper records. But it just depends on the criteria provided by the requester and whether the agency has the ability to search. I'll note here at this point that regulations put out by the Committee on Open Government place an obligation on the agency. The records access officer has an obligation to ensure that somebody within the agency, if the requester comes to your agency and says, okay, you can't find the records I'm looking for because that's not how you maintain your records, I need someone to help me figure out how do you maintain your records so that I can give you the criteria that would allow you to find what I'm looking for. Our regulations state that the agency has an obligation to engage in those conversations. You need to be able to, upon request, you need to explain to the requester, no, we maintain our records by property owner, by lot number, by address. You need to be able to give us that information before we can do a search. That's just an example. So I've mentioned the term Records Access Officer a couple of times now. If you are familiar with FOIL, you're probably familiar with the term. The Records Access Officer is the person responsible for coordinating the agency's response. And every agency has an obligation to, the whole agency has a legal obligation to ensure compliance with the Freedom of Information Law and the corresponding regulations, and they're responsible for designating at least one, and maybe on the size of your, depending on the size of your agency, one or more persons as the Records Access Officer, and they need to be designated by name or by specific job title and business address. And when requests are accepted via email, and let's go on the assumption that there are all agencies should be able to accept requests via email at this point, they should also be able to provide an email address. So if you're an agency subject to FOIL, you should have that information readily available if someone, you know, ideally there's no statutory or regulatory obligation to put it on your website, but that would be wonderful if you did. It would make life a lot easier for everybody if you put that information about how to submit a Freedom of Information Law right up on your website. But if you don't, you should at a minimum, when people call your agency, you should be able to provide that information very, very easily without having to dig. Whoever answers the phone should just be able to say, yep, here's our Records Access Officer and here's how you submit a FOIL request. And that Records Access Officer has the duty to coordinate the agency's response to a public request for access to records. Okay, so for time limits, when an agency receives a Freedom of Information Law request, they have an obligation within the first 5 business days to do one of a couple of things. Within the first 5 business days, they can either provide access to the records sought, they can deny access to the records sought, they can state, we don't maintain the record that you're seeking, or a fourth option, which is more common for larger FOIL requests, is to acknowledge the request and state you need more time. The way the law is drafted, the presumption is, sort of the initial rule of thumb, is that the date beyond the acknowledgement in most instances should not be more than 20 business days. If what the law says is you're supposed to provide a date that's reasonable under the circumstances, but if you're going to provide a date that is longer, farther out than 20 business days, you have an obligation as an agency to provide a date certain that is reasonable under the circumstances, and you're required to provide an explanation for the delay. So whether the explanation is due to the volume of your request, due to the volume of the number of requests we're currently processing, due to the complexity of the request and the need to review those records to determine rights of access. Whatever the case may be, an agency has an obligation to explain why they need more than 20 business days to respond to a FOIL request. I will note for years and years now, our office has interpreted the law to indicate that there's no provision for repeated extensions under the statute. The way the law is written, it is our interpretation that if you need more than 20 business days, you get basically one more bite at the apple. You're supposed to give a date certain, whether that date certain is 1 more month out or 6 more months out or a year out. You get one more bite at the apple, and you're supposed to give a date certain by which you plan to respond. I will note that the courts have not necessarily agreed with our interpretation. They've been a little bit flexible in terms of those time limits. They have not cracked down on agency use of repeated extensions as long as the agency has kept in constant contact with the requester and has kept them updated about the status of their request, and also whether, I think if push comes to shove, the courts are going to look to whether the delays are reasonable under the circumstances. So here you're going to have there's a pretty big distinction between what the Committee on Open Government has opined and how they have interpreted the statute and how the courts have interpreted the statute. So I want you to be aware of that distinction. If an applicant is denied access to a record, they have 30 calendar days to appeal that denial, and the agency has 10 business days to respond to that appeal. Email requests, as I mentioned earlier, there's a provision in the statute that states if an agency is able, it must accept requests by email. In my opinion, every agency should be able to accept requests by emails at this point. It's hard to fathom that there's any agency that doesn't have that ability. Agencies may require that the request be in writing. That's fairly common, but an agency cannot require that a requester use its own form. There's nothing wrong with offering a form for use, having a form available. People love forms, makes their lives easier. However, if someone chooses not to use the agency form, the agency cannot refuse to accept the FOIL request. As long as it's in writing, the requester has complied with their obligation. There are two types of appeals, or there are two types of situations that give rise to the right to file an administrative appeal. The first is a fairly straightforward express denial of access, and that's where the agency affirmatively states to the requester, yes, we possess the record that you're seeking. However, we are asserting one of the statutory grounds for denial, and we are withholding that record in whole or in part. That may, as I mentioned earlier, that may mean withholding the record in its entirety, or it may mean that a couple parts of the record have been redacted. Either situation gives the right to an appeal. The agency has an obligation to put the reasons for the denial in writing and tell the applicant how to file an administrative appeal. The other situation that gives right to the right to file an administrative appeal is a constructive denial of access, and this is a situation where the agency fails to respond to the request within the time limit set forth in the statute. If the agency fails to acknowledge the request within 5 business days, if the agency acknowledges the request and states we'll get back to you within 20 business days but fails to do so, or even perhaps if the agency receives the request, acknowledges the request, but states that they need another 6 months to respond to your FOIL request, those are situations which, in our view, gives rise to the right to file an administrative appeal. The first two situations are a little more straightforward. The agency just clearly failed to comply with the statute. The third is a little bit more subjective because it's a difference between what the requester believes is a reasonable delay and what the agency believes is a reasonable delay. We have model language for anyone that would like to file an administrative appeal. We have model language for standard appeals, and we have model language for appeals when an agency fails to respond in a timely manner, and those are available on our website. So there are several statutory grounds for denying access to records, and we won't go over in every single one of them in great detail, but we'll go over some of the basics. So here and here are all of them, or excuse me, I'm not even going to say all of them. Here are A through I. The remainder are references to provisions of vehicle and traffic law that often have to do with things like red light cameras and things like that, license plate readers, So if you ever have records that involve the application of vehicle and traffic law, there's a good chance that there's a provision in J through Q of Section 87, Subpart 2. That's where all the grounds for denial are located within the statute. There's a series that specifically relate to vehicle and traffic law. So the first ground for denial that I'm going to talk about with a little bit of detail are records that are exempt from disclosure by state or federal statute. Some examples here are attorney-client communications and attorney work product. So there are provisions of the civil practice law and rules that make those communications and those records confidential by statute. If a record is covered by, in many instances, I think I want to back up just a little bit. In many instances, if a record is exempt by state or federal statute, there really isn't an obligation to redact. The record can just be withheld in its entirety because access to those records is governed by a completely different statute. So attorney-client privilege, if you've got an email that reflects a request for legal advice and your municipal attorney's response providing that legal advice, that can be withheld. Student records maintained by school districts, they are entirely exempt by federal law. There's no obligation to, for example, if someone says, well, I would like a copy of a student's education record, perhaps the person who is number 10 in the graduating senior class this year, please provide me with a copy of their transcripts. And you can redact the name. No, you're not obligated to do that because it's access to those records is governed by federal statute. You're not obligated to redact in those circumstances. I used to be the records access officer for the Office of Mental Health. Sometimes we would get FOIL requests for psychiatric records. We had no obligation to even look to see whether we had those psychiatric records because access to those records was governed by mental hygiene law. The same would be true if you have a publicly operated hospital. Medical records are governed by public health law and by HIPAA. You don't even need to think about redacting those records. They are completely exempt from FOIL access because their access is governed by a different statute. There's a couple of lesser known statutes. For example, New York State county law makes autopsy records confidential. New York State county law makes records and transcripts of county-operated 911 calls are confidential. So if someone wants a recording or a transcript of a 911 call, those are confidential by statute. That's upstate New York City is a world unto itself and subject to other rules relating to both autopsy records and county-operated 911 records, but those provisions are going to relate to anything north of New York City and south of New York City, I guess, off to Long Island. New York State Public Officers Law, the Personal Privacy Protection Law makes Social Security numbers confidential. Now, of course, that doesn't mean if you have here's one of the exceptions that I mentioned. If you have a record that contains somebody's Social Security number, no, you're not obligated to, you're not just obligated, but no, an agency shouldn't be withholding that record in its entirety. It should just redact the Social Security number. It used to be that personnel records of police officers and paid firefighters and corrections officers were confidential by statute, but as many of you may know, this summer of 2020, Civil Rights Law Section 50A was repealed, and now instead of access to those records being governed by civil rights law, they are now access to those records is governed by the Freedom of Information Law. Another common example of, and this is a situation often where an agency would choose to redact certain aspects of a record and sometimes withhold in its entirety depending on the situation. When disclosure of a record or a portion of a record would constitute constitute an unwarranted invasion of personal privacy. The examples might be that an agency solicited resumes or applications to fill a position. One person is hired, 10 people are not hired. Someone makes a FOIL request for a copy of the applications of the 10 people that were not hired. The likelihood is you're either going to be withhold those applications in their entirety, or you could redact them in such a sufficient way to protect their identity. So often when people are applying for jobs, they don't necessarily want the whole world to know that they're applying for a job, including their current employers. So you want to protect their privacy. Unsubstantiated allegations of misconduct. Public employees enjoy a lesser expectation of privacy than the general public. So if someone accuses me, Kristen O'Neill, of misconduct, perhaps they're accusing me of time and attendance abuse, or gosh forbid, anything more serious than that, and there's an investigation into those allegations. While the investigation is going on, and if someone makes a request for those records, my agency could withhold on the ground that disclosure would constitute an unwarranted invasion of my personal privacy, because at that point it's just an accusation. Or if I'm accused, there's an investigation and the agency finds that I did not in fact engage in that misconduct, again, those records could be withheld by my agency because disclosure would constitute an unwarranted invasion of my personal privacy. However, if they conduct an investigation and they find that I did in fact engage in that misconduct, any records reflecting the misconduct that I engaged in and any penalties imposed against me, that information should be made public. Medical information contained in an agency's files, whether it's about an employee or whether it's about a recipient of service, can certainly either be redacted or withheld depending on circumstances. Public employees' home addresses can be withheld. That's a specific provision to protect the privacy of public employees who generally have a lesser expectation of privacy. Lists of names and addresses of natural persons if that information would be used for solicitation or fundraising purposes. So if you have an individual that has just opened a mobile dog grooming company and comes to the town hall and says, I would like a list of all the names and addresses of individuals who the town has issued dog licenses to, the town could do one of two things. They could say, well, I can see your truck out there. I can see you're a dog grooming business, so we are going to deny access on the ground that you plan to use this information for solicitation or fundraising purposes. The other thing they could do is, if it's not clear why the person wants the information, is that they can request a certification from the individual that the information will not be used for solicitation or fundraising purposes, and it will not be shared with anyone else who would use it for that purpose. A fairly recent change to the Freedom of Information law relates to mugshots. Up until a couple of years ago, there was a presumption that copies of mugshots were available to the public unless sealed. A change to the law occurred a couple of years ago that now makes disclosure of mugshots an unwarranted invasion of personal privacy. With law enforcement records, it's a two-part test. If a record is compiled for law enforcement purposes, and compiled for law enforcement purposes could mean a couple of things. It could be criminal law enforcement purposes, but it could also be civil law enforcement purposes. And also the word compiled has been fairly recently interpreted by a New York County Supreme Court decision in 2017 that it just doesn't matter just what the record was created for. It matters what was the status of the record at the time that the FOIL request was made. If those records have been pulled together for the purpose, for law enforcement purposes, even if they predated the law enforcement purpose, the courts have held that those can be considered records that are compiled for law enforcement purposes. So, as I mentioned, a two-part test. First, they have to be compiled for law enforcement purposes. And the second part of the test is that disclosure would have to cause one of the harms envisioned by the statute. One is that perhaps it would interfere with a law enforcement investigation or judicial proceeding. Perhaps it would deprive a person of the right to a fair trial or impartial adjudication. Maybe it would identify a confidential source or disclose confidential information relating to a criminal investigation. Or perhaps it would reveal non-routine criminal investigative techniques and procedures. These are the types of investigative techniques or procedures which, if were made commonly known to the public, which may allow the public to evade detection, for example. You don't want to give the bank robber the combination to the safe, so to speak. Another common ground for denial is intra-agency and inter-agency material. The reason for this ground for denial is that it's intended to protect the deliberative process of the agency. So, for example, if you have communications, internal communications or records that reflect advice, opinions, recommendations, impressions, subjective things like that, those records, if they have been maintained internally to the agency, can be withheld in response to a Freedom of Information Law request. However, there's exceptions to this ground for denial. An agency is required to disclose statistical or factual tabulations or data, so objective information. Often this is, data. It's numbers, it's data, that type of thing. So perhaps you're sending an email to your boss making a recommendation, but to support your recommendation, you include some data. The recommendation perhaps can be withheld, but the data would need to be disclosed. Instructions to staff that affect the public needs to be disclosed. A silly example of this is we've got bad weather coming up, and tomorrow we're expecting a big storm, and the Governor's Office Employee Relations sends out an email to all New York State employees in Albany County stating, due to the weather tomorrow, all non-essential employees do not need to appear to work tomorrow. That's an instruction to staff that affects the public, because the public is then going to call my office and perhaps not be able to get a hold of anyone, and they're going to wonder why, and that should be public information. Final agency policy or determination, so if you have policy manuals, bylaws, instructional manuals, those are the types of things that should be made available to the public. And external audits, including audits by the Office of the State Comptroller, those are records that must be made available unless some other ground for denial can be asserted. So we're going back to the appeal. So an applicant for records, when denied access to a record, has the right to appeal. I received a question fairly recently about what types of determinations are subject to appeal, and I talked about that a little bit earlier, but I think it's an interesting question because some things are not quite as straightforward. So I'll give you an example of something that perhaps is not quite as straightforward, but perhaps it's in the best interest of the agency to allow the individual to file an administrative appeal, because it requires perhaps the person making the request to think through it a little bit more, and it requires the agency to think through it a little bit more. One example is if an agency states in response to a FOIL request that the individual has not reasonably described the records sought. It's not a denial in the traditional sense, but it may be worthwhile to, particularly if the records access officer has been perhaps unwilling to engage in conversations with the requester to help them work through the process. If that has not been a successful path to making things work, I think it would be worthwhile for the agency to allow the individual to file an administrative appeal challenging that determination by the records access officer, making an argument that, in fact, they do believe they have reasonably described the records sought and that they have provided enough information to the agency for them to locate the records with reasonable effort. Another situation is fees, which we'll talk about fees a little bit more, but for example, if an agency comes to the requester and states that we have the records that you're seeking, but before we move forward, we need a down payment of $653 to make copies of the records. And the person's like, what are you talking about? And, you know, what I'm asking for can't possibly, making copies of those records can't possibly rise to that level. And again, my encouragement is always to start with try to have a conversation with the records access officer first. Don't necessarily jump right to filing an administrative appeal. Email or call the records access officer and try to get an understanding of what the fee covers. Why am I being charged this? Maybe after an explanation, the person making the request is going to say, yeah, I don't love it, but it seems consistent with the law. Maybe they're going to look at it and say, this just doesn't seem right. I don't think the law contemplates these fees. But the records access officer disagrees. I think that's another situation where it makes sense for the agency to give the individual the right to file an administrative appeal, even though it's not a denial of access in the traditional sense. So when there has been a denial of access, the applicant has 30 calendar days to file an administrative appeal. The FOIL appeals officer by statute is the head or governing body of an agency, or more commonly, the person or persons designated by the head or governing body. The FOIL appeals officer cannot be the same as the records access officer. So if you have, at local levels, what is something common might be that the records access officer is the town clerk, and the FOIL appeals officer is perhaps the supervisor or the town attorney. But the records access officer cannot serve as both, the town clerk cannot serve as both the records access officer and the FOIL appeals officer. In the same way, the town attorney cannot serve as both the records access officer and the FOIL appeals officer. Needs to be two different sets of eyes. Within 10 business days of receiving an appeal, the FOIL appeals officer has an obligation to either provide the records sought or fully explain the reasons for further denial. And sometimes it's a combination. Perhaps sometimes the FOIL appeals officer agrees with the records access officer in some ways and disagrees in others. That's fine. It doesn't have to be one or the other, but they have to either provide records sought or fully explain the reasons for further denial. I'll note that the law does not contemplate a remand back to the records access officer. Generally, it's the responsibility of the appeals officer to review the records at the appeal level. I will note this has come up in a conversation fairly recently. That is not always the practical thing to do. There are times, like I think a common example might be when the reason for the appeal may have been a failure to respond within the time limit set forth in the statute. And now the appeals officer is sitting there with 10 business days and has 5 file boxes worth of records to get through. It's not really practical. So there may be situations, again, it's not contemplated by statute and it would ultimately be up for a judge to decide, but I'm hoping that reasonable minds between the requester and the agency can come to an agreement about what is reasonable. And perhaps in that situation, it may be appropriate for the appeals officer to say, yes, we agree that we missed our deadline due to the volume of your request. We thought we could get it done. We didn't get it done in time. We will make our best efforts and we will get you a response by a date and give a date that you believe is reasonable. And essentially, I know this sounds so legal, but you cross your fingers and you hope for the best. You hope that the person who's making the request understands that this is a reasonable path that will avoid litigation. Fees. People get so confused about fees. I shouldn't say I get more questions about fees than anything else, but I do get a lot of questions about fees. Keep in mind that it's two fee structures. The one fee structure is for photocopies for up to 9 by 14 inches. That if someone wants photocopies of the records, that is all you're allowed to charge for. 25 cents per photocopy, that's it, end of story, done. You are not permitted to charge, an agency is not permitted to charge for search time. They're not permitted to charge for the time it takes to review the records to determine rights of access. An agency is only permitted to charge for photocopies. The second fee structure is for records other than photocopies up to 9 by 14 inches, whether they're larger than 9 by 14 inches or in some other format altogether, which is more common. For example, scanning. If someone says, I would like, you've got 3 file boxes worth of records, but I don't want photocopies because it's going to cost a lot of money. Instead, I want them scanned. If an agency has the ability to scan the records, then it's not significantly more difficult to scan than it would be to photocopy. They would have an obligation to do this. But in this instance, the second fee structure kicks in. And there, you're allowed to charge for, essentially, the two basic things that you're allowed to charge for, because what the law says is you can charge for the actual cost of reproduction for all other records. And then the law tells you what you're allowed to consider when determining that actual cost of reproduction. And this is when the 2-hour rule comes in that people get confused about all the time. The 2-hour rule applies to the time it takes an employee to actually prepare a copy of the record. So if you have a clerk that has to stand at the scanner machine for 2 or more hours, you can charge the salary of the lowest paid employee capable of performing that task. So if it's going to take 5 hours for a clerk to scan all of those records and they get paid $20 per hour, they're allowed to charge the $100 for the cost of making a copy of those records. Again, you are not allowed to charge for search time or review time. That is not what that 2-hour rule is for. The 2-hour rule is just for the cost of the time it takes to make a copy of this record. Another example might be data extraction. You have an IT person that has to sit at their computer for 2 or 3 hours extracting data from a database. That's another example of when that 2-hour rule might be imposed, and you can charge the salary of the lowest paid employee capable of performing the task. You're also permitted to pass along the cost of an electronic storage device. So if the person would like the information put on a thumb drive or a CD, whatever that CD or thumb drive cost your agency, you can pass that cost along to the applicant. Enforcement of the Freedom of Information Law is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. So people contact my office all the time asking me to investigate a complaint and to tell an agency that they're violating the law. I don't have that authority. I can offer an opinion regarding an agency's compliance with the statute, but I do not have enforcement authority. Enforcement would be, it's the next step after filing an administrative appeal. If an applicant for records is unsuccessful after filing an administrative appeal, they can bring an Article 78 proceeding in state Supreme Court. If the applicant for records substantially prevails in the proceeding and the court finds that the agency had no reasonable basis for denying access, attorney's fees are mandatory on the part of the judge. The judge must award attorney's fees in that situation. If the requester substantially prevails and the court finds that the agency failed to respond to the request or appeal within the statutory time limits, attorney's fees are going to be discretionary. Let's see, this is just a quick update on, I don't think we really need to go into this too detailed. It just has to do with fairly recent updates to the statutes that we've already talked about. And this is probably of interest to a lot of people that have law enforcement agencies or are interested in obtaining law enforcement records. When Civil Rights Law Section 50A was repealed, there were certain provisions added to the Freedom of Information Law that govern how there are certain aspects of those records that are required to be redacted, and then there's also certain provisions in the Freedom of Information Law that set forth things that an agency is permitted to redact when reviewing rights of access relating to police officer, corrections officer, and paid firefighter disciplinary records. And we don't necessarily need to go into great detail about that, but that information is available to you all. And I'm going to stop sharing my screen, and we'll go back to, let's see, stop sharing. Now I'm going to let you all see my beautiful face, and I'm going to open up the chat box here and try to go through some questions. If I think that we already addressed them in the program, I will probably skim over, but I will try to get through as many as I can in the next 23 minutes or so. Let's see. Someone asked, oh, I'm sorry, I apologize, I didn't see all of these beforehand because I'm not that talented, but about being able to print out the PowerPoint. As I mentioned, I know I uploaded it to the meeting invite, but I'm not quite sure how to access it. I tried to do it myself and couldn't quite figure it out. I will work on that for my next program. I'll try to make sure I figure out how to make that available. But of course, I'm going to do a blast email to everyone who signed up for the program, and you can have a copy of it for your own records. Let's see. When an applicant uses a FOIL request asking for all documents relating to a specific property in a municipality for a specific period of time, there's usually a very large quantity of documents to review to compile a response, long email threads, letters, reports, duplicates. Sometimes this comes down to whether the person has reasonably described the records sought. I'm an attorney, so I feel comfortable bashing my own, but sometimes municipalities get requests, particularly sometimes from attorneys, that read like discovery requests. And they want any and all records, including but not limited to. And in my view, requests of that nature do not always reasonably describe the records sought. One option might be, for example, I mean, if it's just records that are actually contained in a physical paper file, that may not be so complicated. But when you're talking about when they're asking for any communications relating to a specific property, that's very difficult to determine. If you may need to go back to them and say, well, can you give me names of employees that you believe may have been involved in these communications? Can you provide me with a very specific date range or dates that you believe these communications occurred? Just expecting an entire municipality to search all of their emails for something that may relate to a property when there just may not be an easy way to do that. You may have communications that don't even necessarily reference the property. So it may be that the response is, here's what we can give you, but to the extent that there may be other records that are responsive to your request, we are unable to locate them with reasonable effort. So that may be an appropriate way to respond. This is the type of thing where, you know, when it gets to nitty-gritty, please feel free to reach out to me, call me, and give me or send me an email. It might be something I can help you to work your way through. Let's see. Also, this is a good question about weaponizing FOIL and harassment. It's a good, interesting question. I think certainly a large percentage of members of the public are using the Freedom of Information Law for a proper purpose. They're just interested in how their government is functioning. They are trying to obtain information. They want to see how their tax dollars are being spent. They want more information perhaps about a project that's going on. They're using it for a proper purpose. However, in my 5+ years here, I have come across people that simply really don't even care about the records that they're obtaining. They're just angry. They're angry and they're using the Freedom of Information Law as perhaps a tool for harassing the government employees. This is very uncommon in the large scheme of things, but regrettably it's a little bit more common than I would like. I deal with municipal employees every day, and they're good people. You know, many of the government employees that I deal with are excellent civil servants who are just trying to do their jobs, and they have many responsibilities. FOIL is one of which, and they just want to do a good job. But sometimes the FOIL requests that they receive are interfering with their ability to do that. And that is not to say that FOIL should be considered an interference. FOIL is a statutory obligation. It's one of an agency's many responsibilities. But there are certainly times when it seems that the person who's making the FOIL request does not have honorable intentions. And the best I can really do for you there is to talk to perhaps your municipal attorney to see whether it has perhaps risen to the level of harassment. Because basically if you stop responding to FOIL requests, you're going to be exposing your municipality or your agency to legal liability. So you want to be able to consult with your attorney, keep good documentation of all steps that you've taken to be compliant with the Freedom of Information Law, and if you feel that it gets to the point where continuing to respond to a particular individual is not beneficial, you want to make sure that you're working with your attorney to be on solid legal ground in case you get sued. I know that's not really a great answer, but it's probably the best I can offer you. Someone asked about who appeals officer for public community boards is. All I can tell you, just too many units of local government for me to really know, and it's up to each government agency to appoint. What the law says, it's the head or governing body of the agency or the person designated by the head or governing body of the agency. This should be something that often this information is contained in an agency's policy. Every agency is supposed to have a FOIL policy or regulations. You can always ask for a copy of the policy or regulations. In the alternative, you can contact the Records Access Officer and find out who handles appeals. Sorry, there's a beep there. I wonder what that was for. Let's see. Someone asked what happens when a FOIL appeal is ignored by the appeals officer. They go on to say, my only recourse to file an Article 78. Unfortunately, the answer is yes. Your legal remedy, if an agency fails to respond to a FOIL appeal within 10 business days, at that point, you have the right to initiate a civil practice law and rules Article 78 proceeding. I've been foiling or trying to get emails between the mayor and other council members, wondering if in public capacity are emails foilable, and mentioned earlier that all records maintained by an agency are subject to the Freedom of Information Law. Whether they need to be disclosed is going to depend on content. To a large extent, internal emails between the mayor and council members are going to be exempt under the intra-agency material exception that I mentioned earlier. Just honestly, so people know that if you submit like technical questions on the chat function, it's probably not something I'm going to be able to help you with. I'm not a tech person. I am probably in the same boat as all of you. Let's see. Okay, so one of the questions that was posed is, right now during COVID times, what happens if an individual would like to view records, but the public offices are closed? To a large extent, this is going to depend on how the agency feels is the most appropriate way to handle it, considering the public health needs of its employees and the public. If the agency can provide access to the records electronically at no cost, that might be an option other than providing a time for inspection. If the agency feels like it can open doors by appointment to a small number of people where the agency can socially distance and make those records available for inspection, that's an option. Another option, regrettably at this time, may be, under certain circumstances, that inspection really just isn't an option right now while municipal offices are closed to the public. That just may be an unfortunate, regrettable result of the COVID situation right now. Let's see. There's a question here that's very specific to an entity that I'll just have that person can contact me directly about. If you have questions or complaints about a particular agency or public body, that's probably really better to just contact me directly instead of us getting into a detailed discussion regarding the problems relating to a particular agency. Someone asked about a combination where if there were allegations of misconduct and some were substantiated and others were unfounded, you can request copies of the records and they would have an obligation to redact, most likely. They can redact the aspects of the records that relate to the unfounded allegations of misconduct and disclose the aspects that related to the substantiated allegations. Let's see. Are unsubstantiated allegations of discrimination treated as the same as allegations of misconduct? Yes, I would say that falls under the same heading. Right to appeal. What if the agency has refused to even acknowledge receipt of a FOIL request, and why is it not called a requirement? If it has refused to acknowledge, then it has failed to respond to the time limit set forth in the statute, and you have time to, you have the right to file an administrative appeal. And, you know, sometimes the language we use is about courtesy, about treating other people with respect, and it was by the legislature, you know, implemented by the legislature before, I shouldn't say before I was born, but when I was very young, and I cannot speak to that. In order to force a public agency to respond to FOIL, what is the court or which court system to petition for a response from a court? You're going to want to file an Article 78 proceeding in your local Supreme Court. So, for example, if you're in Albany County, it would be Albany County Supreme Court, Broome County, New York County, Bronx County, whatever county you are in, or you can also probably file it within the agency, the jurisdiction where the agency is located. Someone asked, do you recommend getting an opinion from your office before filing an Article 78? Yes, if you want to find out whether your arguments are strong and whether you would have a good chance of prevailing in an Article 78 and you would like an opinion from our office, I certainly encourage you to do it before you file the Article 78, because once you bring the Article 78, our office will not get involved. In terms of attorney's fees, it's not really my area of expertise about what happens in terms of actual awarding of attorney's fees. That's a litigator's area, and so I just asked about when you bring in Article 78 without an attorney, do a pro se, what would you get in terms of reimbursement? And that's not really my area of expertise. I'm going to email this. Someone asked about the slideshow. I am going to email that to everyone. Someone's asking about mugshots. Then mugshots should be public information. Is this until the time a person has been found guilty of what they were arrested for? Well, the way the language relating to mugshots was drafted is that it was included as an example of an unwarranted invasion of personal privacy. But there's also language that states that a law enforcement agency can make mugshots available if it's for a legitimate law enforcement purpose. So, for example, if, God forbid, I did something terribly stupid and was arrested for DWI, and they take my mugshot, and someone who just really wants to embarrass me, or this actually came about because there were companies that were culling the internet for these mugshots and then posting them on their website and then getting people to pay to have it removed. So it's almost like they were, blackmail is too strong a term and it's a legal term, but basically in order to have your mugshot taken down off of this website, you had to pay them. And part of the intent of this legislation was to prevent things like this so that the internet was not inundated with mugshots that would, follow people throughout their lives. So I have my mugshot taken, I'm arrested, I go through the proceeding, and perhaps it's either dismissed or reduced to a non-criminal offense. But the problem is the mugshot's still out there. Someone could make a Freedom of Information Law request. If my record's been sealed, it shouldn't be disclosed, but if I was convicted of the offense, people could still get access to that mugshot. The intent of the law was to try to prevent that so that these mugshots could not be used for either, again, blackmail is really too strong a word and I'm not thinking of the right term, but trying to get people to pay to have this information taken down. It shouldn't be, mugshots shouldn't be used to embarrass private individuals. However, let's use another situation, as I'm sure many of you recall years back now, a couple years back now at this point, when there was the escape from Dannemora, and there was mugshots of these individuals that had been convicted of terrible crimes and had been serving time in prison. Well, all around the state, their mugshots were posted everywhere because it was for a legitimate law enforcement purpose. The law enforcement wanted the public to be aware of what these people looked like to assist in locating these individuals that escaped. And of course, this happens on a much smaller scale in localities, but that's sort of a big example of, everyone was probably aware of it at the time. Mugshots can be continued to be used for a legitimate law enforcement purpose. But if a FOIL request is made for a copy of a mugshot, I'm there's no legitimate law enforcement purpose for the request, the likelihood is that the agency would choose to withhold on personal privacy grounds. It's actually not to say that they're required to withhold. Local law enforcement are not required to withhold the mugshots. They just have the ability to. Someone said, can you touch upon requests from incarcerated persons for their documents? I'm not exactly sure what this means, but I know that I often see copies or appeals of requests for inmates for like everything in their criminal file. Like, for example, maybe the request is going to the arresting agency or the request is going to the district attorney's office. And some of the things that that agency is going to want to look at is whether these records were already made available to the defendant or the defendant's attorney during the defendant's trial. If so, there's no obligation to redisclose. If they're making other requests, if the inmate is making requests for records that were never disclosed to them in the past, you just essentially need to treat it like any other person. You're going to treat that inmate like any other FOIL request and address the request just like you would address any other FOIL request. There's a recent decision by Honorable Judge Powers. How does that affect in preparing the FOIL request from Muck Rock? I'm not sure if we're talking about the Schenectady. There's Schenectady County, and there's the Schenectady case with. There's a case out of Buffalo. I mean, at this point, we have advisory opinions on our website relating to requests for police disciplinary records. They're available right on our homepage, and in my opinion, they're still valid. Are emails sent on a personal account ever FOILable? The answer is yes. If a public employee is using their personal email account to conduct public business, those are records subject to FOIL. When a city project looks for comments and we FOIL the comments, what can be redacted? Name, email, anything else? In my opinion, if someone is submitting comments on a public project, to a large extent that information should be public. I think contact information such as phone numbers, emails, home address could likely be redacted. There may be other very specific situations where there might be privacy or safety concerns, but to a large extent that information should be public. Record retention is not governed by the Freedom of Information Law. It's governed by the New York State Archives Record Retention and Disposition Schedule. My recollection, but you're going to want to double check me on this, is that the record retention period for FOIL requests and the FOIL responses is 6 months from the final determination. So if you receive a FOIL request and you just respond to it in full, done, end of story, it would be 6 months from that date. If you deny access and they file an administrative appeal and you respond to the administrative appeal, it's going to be 6 months from that date. So that's my recollection of the record retention and disposition schedule for FOIL requests. But if you're a local government, you're going to want to check the LGS-1. Someone just made a comment about intentional use of private email to avoid creating public records. Well, they're not really avoiding creating public records, because if someone's using their private email account to conduct public business, those are records subject to FOIL. Someone just made a comment about intentional willful failure to create records of meetings, then denying a FOIL request by saying records are not available and not required to create records. I'm not sure what type of records we're talking about. I mean, obviously there's an obligation under the open meetings law to prepare minutes within 2 weeks of a meeting. In addition, the governor's executive order relating to the suspension of the in-person requirement there's an obligation, if you're having remote meetings, there's an obligation to record and later transcribe. the recording in my mind would be available immediately. Transcriptions are more difficult because it could be time consuming, so it depends on when the request is submitted, I suppose. When an application is denied, should packet be forwarded to appeals officer? In theory, when an individual makes a Freedom of Information Law request, they're supposed to give the appeal officer enough information to work with. They should ideally provide, at least if they're not providing copies of the request and their request response, they should at least be providing enough details so that the appeal officer can get it themselves. The appeal officer would have an obligation to go to the records access officer and get any information that they believe is necessary to respond to the appeal. Someone's asking, is it okay to have the attorney's office for a county prepare a decision for an appeal? I think what needs to occur is it's about an appeals officer working with their legal counsel to respond to a FOIL appeal. And I think what's important to distinguish here is that if the attorney's office is preparing the decision, then the attorney's office should be appointed as the appeals officer. That's my opinion. If you have, like, for example, the county's attorney's office is the one actually preparing the appeal determination, then the attorney's office, the county attorney's office should be signing the individual or individuals assigned, designated to handle FOIL appeals. But this is it's not specifically addressed by statute, and it's something, if the person who submitted the question, we can talk about offline. There's a series of questions from that individual about that, and we can talk about that offline. How do we get a copy of a record retention and disposition schedule? It's available on the New York State Archives website. Can we give the names of employees and their contact information? Names of all public employees should always be publicly available. In terms of contact information, that depends, and it depends on whether they're direct lines, cell phone numbers that may not be directly available to the public. Email addresses of public employees are generally going to be public. State law requires a copy of the appeal determination be sent to COOG. What is meant by determination? Does that mean we need to send the cover letter as well as the records? I'm going to let you know that I don't want copies of the records. We just wanted a copy of the determination letter. If for some reason we need to follow up and we have questions about the response, maybe we'll follow up with you and ask to see copies of the records. But in general, as an agency, if you're providing us with a copy of the determination, I really just want to see the legal analysis, the cover letter that went to the applicant. Political committees are not agencies subject to FOIL. I'm going to skip over some of these questions because I'm already over, and I just want to try to see if there's anything that jumps out at me. Something that Someone's asking if exporting data takes more than 2 hours and the applicant would like the information emailed, can per hour fee be charged? It's about employee time, in my opinion. So, for example, if someone just starts the process, IT person sits down at the computer, starts the process, and then can walk away and doesn't need to oversee the extraction or exporting, I don't think that's not really employee time. If, however, the person who's responsible for exporting data actually has to be sitting at their computer for 2 or more hours, then yes, they can charge the salary of the lowest paid employee capable of performing a task. Someone's asking a good question about if an agency responds by stating that they do not have records that are responsive to the request, is that appealable? In my opinion, it is not. It is not. What the person's remedy at that point is to request a certification. Sometimes a request for a certification may cause the agency to take a second look just to be sure, because of course a certification is a legal document and they want to make sure that they're not falsifying, filing a false instrument by stating that they have no records when in fact they do. But in my opinion, no, it is not an agency's statement that they do not have records that are responsive to a request is not a denial of access that's subject to appeal. Someone asked about whether we have advisory opinions about harassment, use of harassment, and we really do not. If you get a request for an entire listing of active directory county employees, which they are requesting all county employees in their phone directory and all of their attributes, which is very vague. I'm not sure what that means either. What's required by FOIL is name, title, salary, and physical work location. In terms of the phone directory, my belief is that needs to be looked at to determine whether disclosure of direct lines, is that going to interfere with the employee's ability to do their job? If, for example, a listing of direct phone lines is posted online and they start getting tons of phone calls that have absolutely nothing to do with their day-to-day job. No court has weighed in on this, but my belief is that a personal privacy argument could be made because it's interfering with that individual's ability to do their job. The same might be true of a government-issued cell phone where the number for that cell phone is not really, it's really only available to a limited number of people. Someone asked about redacting FEIN numbers. FEIN numbers are generally public information. If you go online, many FEIN numbers, you can find them right online. You can find them, if it's a not-for-profit, you can find it on GuideStar. There's an exception that I was made aware of years ago by the New York State Tax Department relating to years and years and years ago when an individual wanted to sort of maybe start a sole proprietorship. So basically they were the only person, it was a business, but they were the only employee. Sometimes what the IRS would do was they would convert their social security number, they would just move the hyphen and turn it into an FEIN. So if you think that's possible, you may want to redact the FEIN, but if you're talking about a large corporation or a large not-for-profit, generally there really would not be any ground for redacting the FEIN. Someone asked if I was reading questions from Q&A or chat, and I'm doing chat. And if the documents are available on our website, are we required to take the time to track down the information and print it, or can we just tell them it's available on our website? I would not recommend just telling them it's available on your website. I would provide them with direct links. I don't think you have to print it unless they very, very specifically say they want it printed. Someone comes to you and says, I am not computer literate, don't have access to the internet, I can't go online, I need printed versions. Yes, unfortunately, you're going to have to print it out. If someone emails you and asks for documents that you know are available on your website, you can point them to the direct link. But I wouldn't just say, it's available on the website, find it yourself. You're going to need to provide them as direct a link as possible to be responsive. And so I may have skipped over a couple of things, but I went way over, so I just want to say thank you all for participating today. I will get this posted up online if people would like to see it, and my plan is to do this every other month, alternating with OML. So next month in March, I'll do an OML program. I'll do another FOIL program in April if people want to let other staff, if other staff might be interested. Thank you all for participating, and you all have a great day. Thank you.